A short time ago, I came back from court having argued a motion to dismiss, and I thought it would be a good time to explain what a motion to dismiss is and how it's used in a lawsuit. Hi, my name is Peter Lamont, and I'm a business and personal law attorney practicing here in the state of New Jersey. Now, a motion to dismiss is a means of dismissing the complaint, but it is different from a summary judgment motion, which we talk about in detail in another video. The standard for review is completely different. In a motion to dismiss, the court takes the allegations and facts contained in the complaint, and they deem them, for the purposes of this motion, to be true. What the court is looking at is whether or not your allegations can sustain the particular cause or causes of action that you are alleging. Now, when you receive a complaint, you typically would file an answer. However, if you receive the complaint and you look at it and you know there's no way that these allegations are either pled properly or apply to you, you could file a motion to dismiss instead of filing an answer. Now, in the case that I was on today, it was a case that was brought against a doctor, and the allegations were negligence against this particular physician. Now, this physician did see the patient in his office for a very brief time and ultimately told the patient that he could not assist her. And so his treatment was limited to that one office visit, and his file is documented saying, could not help the patient, and so I'm closing my file. Now, she's involved in a lawsuit where she's suing multiple doctors and hospitals and facilities, and so my client was dragged into the mix. So when he received the complaint, he called me up and he said to me, I didn't even treat this person. Why should I be in this lawsuit? So what we were able to do, based upon his record, his facts that he only saw her once, we were able to file a motion to dismiss and argue that there is no cognizable cause of action that's alleged against our client because of impossibility. So in other words, we didn't treat her. You've got the wrong physician, and therefore you can't maintain a cause of action against this physician. And the court agreed with us and basically said, yes, that's correct. If there's no evidence to support this allegation, it's just a baseless allegation, then the motion to dismiss has to be granted. Now, other times, motions to dismiss are used to force the plaintiff to refile or replead his complaint. And this is shown in examples where somebody has a fraud count in their complaint. Now, in New Jersey, New York, and in most states, you must plead your fraud count in a complaint with specificity. In other words, it's got to be specific. It's got to discuss specific details of how and when the defendant allegedly defrauded you. So it's not good enough to say he committed fraud and therefore I'm entitled to money. You need to explain the facts surrounding the fraud and how it all occurred. So oftentimes you'll get a complaint like that where it's this bare bones, he committed fraud, and you'll receive in response a motion to dismiss. And the motion to dismiss is brought under the theory of failure to state a cause of action. And the argument made to the court is, Judge, this complaint does not state a proper cause of action for fraud. It's not pled with specificity, and therefore it should be dismissed. Now, the courts will typically dismiss something like that without prejudice, meaning that if the plaintiff can redraft the complaint and provide those specific facts needed, then he's entitled to refile the complaint. Oftentimes, it's used as a tactic by lawyers to either gain more time or to show the other side that they're very serious about defending a particular claim. Now, a motion to dismiss can't be used in every case. You can't file a frivolous motion for the sake of filing it. There needs to be good and sufficient legal grounds to do so. Now, if you have any questions about motions to dismiss or any legal matter, I encourage you to pick up the phone and give me a call. I answer legal questions just like the ones that you might have on a daily basis. I can be reached via telephone at 973-949-3770, or if you prefer, via email at plamont, that's Lamont, at peterlamontesq.com. Thank you for joining me today.